Hello everyone, welcome again. Today it's our third day of a series of lectures whereby we are reading Indian Contract Act 1872. So let's start. Today we have specific and general offers. When the offer is made to a specific or an ascertained person, it is known as specific offer. But when the same is not made to any particular person but to public at large, it is known as general offer. For instance, an offer to give reward to anybody who finds a lost dog is a general offer. This general offer is deemed to be accepted by anyone who actually finds the lost dog. The person who accepts this offer, generally by performing the condition of the proposal, can bind the person making the offer. देखिए, जैसे यहाँ पे हमें एक एग्जाम्पल दिया गया है जहाँ पे क्या क्या ऑफर है दैट एनीबडी who finds a lost dog. So here anybody suggests that it is a general offer. So any person who finds that particular lost dog is said to have accepted the offer. The person who accepts this offer generally by performing the condition of the proposal can bind the person making the offer. Although an offer is made to a public at large, the contract is concluded only with the person who acts upon the terms of the offer, that is, who accepts the offer. So the person who finds the lost dog is the only person with whom a contract is being concluded. It is settled that two manifestations of a willingness to make the same bargain do not constitute a contract unless one is made with reference to the another. यहाँ पे क्या बात की गई है? क्रॉस ऑफर्स के बारे में बात की गई है. दैट इफ़ टू मैनिफेस्टेशंस ऑफ ए विलिंगनेस टू मेक द सेम बार्गेन, तो क्रॉस ऑफर्स में भी ये होता है, दो पर्सन हैं ऑफ़र करते हैं और उस ऑफ़र में सेम टर्म्स ऑफ बार्गेन होते हैं. ठीक है. डू नॉट कंस्टिट्यूट अ कॉन्ट्रैक्ट अनलेस वन इज़ मेड विद रेफरेंस टू द अनदर. तो जब तक कोई एक पर्टिकुलर पर्सन अपनी विलिंगनेस को शो नहीं करेगा और उसके रिप्लाई में दूसरा उसको एक्सेप्ट नहीं करेगा, तब तक एक कॉन्ट्रैक्ट कंक्लूड नहीं होता है. तो यहाँ पे हमारे पास एक बहुत इंपॉर्टेंट केस है रिलेटेड टू जनरल ऑफर. ये है कार्लिल वर्सेस कार्बोलिक स्मोक बॉल कॉर्पोरेशन. The defendants advertised their product, Carbolic Smoke Ball, a preventive remedy against influenza. In the advertisement, they offered to pay a sum of £100 as reward to anyone who contracted influenza, cold, or any disease caused by taking cold. After having used the smoke ball 3 times a day for 2 weeks, in accordance with the printed directions. They also announced that a sum of £100 has been deposited with the Alliance Bank to show their sincerity with the matter. The plaintiff, Mr. Carlyle, relying on the advertisement, purchased a smoke ball from a chemist, used the same in accordance with the directions of the defendant, but still caught influenza. She sued the defendants to claim the reward of £100 advertised by them. It was held that this being a general offer addressed to all the world had ripened into a contract with the plaintiff by her act of performance of the required conditions and thus accepting the offer. She was therefore entitled to the reward. तो बेसिकली इस केस में क्या हुआ था, जो डिफेंडेंट्स थे कार्बोलिक स्मोक बॉल कॉर्पोरेशन, उन्होंने एक अपना प्रोडक्ट बनाया. ठीक है. एक रेमेडी बनाई अगेंस्ट इन्फ्लुएंजा जिसका नाम था स्मोक बॉल्स. तो उन्होंने एक एडवर्टीज़मेंट रिलीज़ की. उसमें ये कहा कि जो भी पर्सन स्मोक बॉल को 3 times a day फॉर 2 weeks यूज़ करेगा और उसके बाद भी इफ़ ही कॉन्ट्रैक्ट्स इन्फ्लुएंजा देन दे वुड पे £100 टू सच अ पर्सन. तो रिलाइंग अपॉन दिस एडवर्टीजमेंट, मिस्टर कार्लिल परचेज स्मोक बॉल फ्रॉम अ केमिस्ट, and even after using it in accordance with the directions of the defendant, he caught influenza. So she sued the defendants to claim the reward. It was held that this general offer is addressed to the whole world, and Mrs. Carlyle, by following the directions given by the defendants, has accepted the offer. So, a contract is concluded between Carbolic Smokeball Corporation and Mrs. Carlick, and therefore, Carbolic Smokeball Corporation is bound to pay the reward of £100 to Mrs. Carlick. The following of wheat from 1st January to 31st December in accordance with the orders which may be placed from time to time is a standing offer. As and when the orders are placed, that amounts to acceptance of the offer to that extent only. So यहाँ पे हम एक बात नोट करने वाली बात ये है, एक ऑफर दिया गया टू सप्लाई 1000 bags ऑफ wheat, ओके, from 1st January to 31st December in accordance with the orders which may be placed from time to time. तो जितना ऑर्डर प्लेस किया जाएगा उसके अकॉर्डिंग ही सप्लाई की जाएगी. एंड when orders are placed, then it amounts to acceptance only to the extent of that order. For example, a person orders 100 bags, then it is only the acceptance of the offer up to 100 bags, not more than that. In the above stated illustration, if an order for the supply of 100 bags of wheat is placed on 15th January, there is an acceptance of the offer to that extent, only to that extent, and the offerer become bound to supply those 100 bags of wheat. So far as the remaining quantity is concerned, this offer can be revoked just like any another offer. Acceptance of a tender for the supply of goods is a kind of standing offer. An advertisement inviting tenders is merely an invitation for quotations. When the tender is approved, it becomes a standing offer. As and when an order is placed on the basis of the tender, that amounts to the acceptance of offer and results in a binding contract. Such an offer may be revoked or withdrawn before the order has been placed. Even though the offer is originally made opened in a particular time, it may be revoked earlier than that, because the offerer is not bound to keep the offer subsisting and he may revoke it any time before its acceptance. So basically, we have to understand that the offerer is not bound to keep the offer subsisting and he may revoke it any time before its acceptance, because as and when orders are placed, then it amounts to acceptance only to the extent of order, and the remaining part is still not accepted. So it cannot bind the offerer to subsist the offer. So he can revoke it anytime he desires, but it must be before its acceptance. So next we must understand a case law. Yes. Rajendra Kumar versus State of MP. The respondents, State of MP, invited tenders for the sale of tattoo patta, a kind of leaves. The petitioner, Rajendra Kumar Verma, submitted his tender and also deposited some security. The tender was to be opened on 9th April 1969. Before that date, the petitioner made an application withdrawing his tender and requested that on the stipulated date, the tender be not opened. In spite of the petitioner's application, his tender was opened, and that being the only tender, the same was also accepted. The petitioner refused to execute the agreement to purchase the leaves. The government sold the leaves to somebody else and then sued the petitioner to recover damages amounting to Rs 25,000. One of the contentions of the respondent was that there was a clause in the tender notice according to which the petitioner, having submitted his tender, was not entitled to withdraw the same. It was held that in spite of such a clause in the tender notice, the tender or an offer could be withdrawn. And therefore, in the present case, since the offer had been withdrawn, no contract had arisen between the parties, and the petitioner could not be made liable. तो यहाँ पे क्या हुआ था इस केस में कि जो स्टेट ऑफ एमपी था इट इन्वाइटेड टेंडर्स फॉर द सेल ऑफ टेडू पत्ता लीव्स. तो in accordance with the invitations for the tenders, Mr. Rajendra Kumar submitted his tender. Please note that when a person makes a tender, then here the person submitting his tender is the offerer. So Rajendra Kumar Verma was an offerer. So tender was submitted, and before it could be opened, Mr. Rajendra Kumar Verma withdraw his tender. So here offer has been revoked before its acceptance. Therefore, it is not an offer now. But in spite of its revocation, State of MP accepted the tender and sued the petitioner to claim damages. It was held that after the revocation they could not accept the offer. But respondents contended that the tender notice contained a clause in which it was stated that a tender once submitted cannot be withdrawn. तो रिस्पोंडेंट्स ने क्या कंटेंट किया कि हमने टेंडर नोटिस में एक क्लोज डाली थी जिसके अकॉर्डिंग अगर कोई टेंडर सबमिट कर दिया गया है तो उसको विड्रॉ नहीं किया जा सकता. लेकिन मध्य प्रदेश हाई कोर्ट ने क्या कहा, दैट इन स्पाइट ऑफ सच ए क्लोज the tender or an offer could be withdrawn. Here, Madhya Pradesh High Court observed that a person who makes an offer is entitled to withdraw his offer or tender before its acceptance is intimated to him. The government, by merely providing such a clause in tender notice, could not take away that legal right of the petitioner. The fact that petitioner had applied for withdrawal of the tender is not denied. That when the tender were opened, there was really no offer by the petitioner, and therefore there could be no contract impliedly or explicitly between the parties. Next, we have another important topic. So let's move on to the page number 25. That is acceptance. We all know that a proposal, when accepted, becomes promise. Promise, when a consideration is added in it, then it leads to an agreement. And when an agreement is enforceable by law, it becomes contract. So, a proposal, when accepted, results in an agreement. It is only after the acceptance of the proposal that a contract between the two parties can arise. According to section 2b, when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. A proposal, when accepted, becomes a promise. A person making the proposal does not become bound thereby until its acceptance. As soon as his proposal is accepted, that is known as promise, whereby both the parties become bound. When the proposal or acceptance is made in words, the promise is said to be express. When the proposal or acceptance is made otherwise than in word, the promise is said to be implied. So ये कौन सा सेक्शन की लैंग्वेज है? सेक्शन नंबर 9. तो सेक्शन नंबर 9 हमें क्या कहता है? The offeree is not bound to accept the offer. He is free to reject it or make it to lapse by non-acceptance. Thus, it is perfectly lawful for a company not to accept the highest bid and to re-auction the goods. Similarly, a person inviting tenders may not accept a bid if an essential condition of a tender is not complied with. A person inviting tenders may reserve a power to reject all the tenders. The person submitting the highest tender cannot have a right to have his tender accepted. So, offeree is free to accept or reject the offer, and he is not bound to accept the same. It depends according to his will. Next, we have effect of acceptance. A contract is created only only after an offer is accepted. Before the acceptance is made, neither party is bound. So, a contract comes into existence when an offer is accepted. Before acceptance, neither party can be made liable, neither party is bound thereby. At that stage, the offerer is free to revoke or withdraw his offer, and the offeree is free not to accept or to reject the same. After the offer has been accepted, it becomes a promise, which, if other conditions of a valid contract are satisfied, binds both the parties to the promise. After acceptance, each party becomes legally bound by the promise made by him through the medium of offer and acceptance of it. The effect of acceptance of an offer has been explained by Anson in the following words. Acceptance is to an offer what a lighted match is to a train of gunpowder. It produces something which cannot be recalled or undone. But the powder may have lain until it has become damp, or man who had laid the train may remove it before the match is applied. सो यहाँ पे क्या कहा गया है दैट एक्सेप्टेंस इज़ टू एन ऑफर व्हाट अ लाइटेड मैच इज़ टू अ ट्रेन ऑफ गन पाउडर, यानी एक्सेप्टेंस ऑफर के लिए ऐसा काम करता है जो एक लाइटेड मैच एक गन पाउडर से भरी हुई ट्रेन के लिए काम करेगी. तो अगर कोई ट्रेन है गन पाउडर से भरी हुई और अगर हमने उसमें लाइट मैच डाल दी तो वो एक्सप्लोड होगी, बर्न होगी और कुछ ऐसा इफ़ेक्ट प्रोड्यूस करेगी जिसको हम चाहते हुए भी दोबारा ओरिजिनल पोजीशन में नहीं ला सकते हैं. तो इसी तरह अगर एक बार ऑफ़र एक्सेप्ट हो गया देन इट कैन नॉट बी रिवोक्ड. सो अ ऑफर वंस एक्सेप्टेड becomes a binding on the offerer. Just as when the lighted match comes in contact with gunpowder, there would be an explosion and then it will not be possible to bring the things back to original position. Similarly, after the offer is accepted, it creates a contract where both the parties become bound and none of them can go back. What happens after explosion or after acceptance cannot be undone. There is a possibility that in course of time, the powder may have become damp or the train of gunpowder may have been removed. And in that case, the damped powder or the one which has been removed will not create an explosion. In the same way, the offer lapses if the same is not accepted within the prescribed time, or if no time is prescribed by remaining unaccepted until the expiry of reasonable time, or else the offer could be revoked by the notice of revocation by the offeree. Once the offer lapses or is revoked, it is incapable of being converted into a contract by being accepted. Thus, the acceptance of the offer while the same is still alive would result in a contract creating obligations for both the parties. So that's all for today, friends. We will continue our reading sessions and I will post videos as soon as possible so that you all could continue your study. So stay tuned with No Legal World to know the legal world. Thank you very much.